the August 2 memorandum confirms the acting attorney general's understanding both at the time of our appointment and as of the time of that memo that these crimes are within the scope of our authority. And the explanation for the greater detail in the August 2 memo is that the public order was not the place or occasion to provide details about the matters that the special counsel was to investigate. So we are not operating off the range of what the acting attorney general has authorized us to do. I would respectfully submit that under the Fourth Circuit law, the regulation that Mr. mannaFord is relying is not a judicially enforceable matter. I understand Your Honor's view on that. I think we have provided case law on why we don't think it's a matter for judicial enforcement. Even if the court does, we do have written confirmation that the matters in the indictment are within our scope. Thank you, Your Honor. The court responds, thank you. All right, I have actually heard probably most of their argument, and I haven't heard all of yours. You may now tell me what you think. Mr. Downing responds, well, first of all, Your Honor, good afternoon or good late morning. I don't know if you had any questions you would like me to start off with answering as opposed to just reiterating what's in the brief. But I will say, and the court responds, well, I don't want you to reiterate what's in the brief. I've read that. Mr. Downing, okay. The court responds, it's now your opportunity to bring out what really you think is dispositive in some arresting, interesting way. Mr. Downing, that's setting the bar high. The court responds, I reminisce a lot. The world has changed. I was a student in England in the late 60s, and I went to many oral arguments. They didn't use briefs at all in the cases I went to. In the House of Lords, the judges appeared in suits, and the lawyers appeared, and the barristers appeared in wigs and robes. They together bent down, pulled books off the shelf, and read cases together and argued about them. I thought that was a charming but ineffective way to do things. Writing briefs is much more effective, but then it kind of renders oral argument a little more uninteresting. Tell me why you've heard him say, I mean, their argument is fairly straightforward. They say you look at the May 17th letter, it says any links and or coordination between the Russian government and individuals associated with the campaign of President Donald Trump. Secondly, any matters that arose or may arise directly from the investigation, which I focused on their investigation rather than the Department of Justice's. But that's a fair point. And then the third one is any other matters within the scope of 600.4 of Title 28 Code of Federal Regulations. Then counsel appropriately called my attention to the August 2 memorandum from Rosenstein, which amplifies that a bit. Of course, most of the letter is redacted, but I'm advised that it doesn't have anything to do with Mr. mannaFord. I'm going to look at that myself. But that goes on to say whether crimes were committed by colluding with Russian government officials with respect to the Russian government efforts to interfere with the 2016 election for president. That was pretty clear from the May letter. But then they go on to say committed a crime or crimes arising out of payments he received from the Ukrainian government before or during the tenure of President Viktor Yanukovych. Viktor Yanukovych. Okay. Well, we could argue all day here and not get very much clarity on whether there's a difference between the Ukraine and Russia. Of course, I wasn't there any later. I think the stenographer's getting tired here. They're typing it because there's starting to be some mistakes. I'm not, I'm just reading the words here. So I think it means it wasn't, uh, I wasn't there any later than about 40 years ago. Okay, that makes sense. But if you ask the average Ukrainian, they will tell you there's a huge difference. On the other hand, the government makes a very powerful point. Yankovic's operation was supported by the Russian government. He did essentially what they wanted him to do, but he's not there anymore. People are killing each other in the eastern Ukraine. My hunch is that it's Ukrainians and Russians that are mostly fighting. Mr. Downing responds, actually, Your Honor, we spent a lot of time on this issue. For the work that Mr. Manafort was involved with Mr. Yankovic, they were very, and then the court cuts him off and says, they were very what? Mr. Downing, they were leaning towards getting into the European Union. They were actually trying to get further away from Russia. Those were the efforts of Mr. Manafort. For today, I will say that the first comment that you had has to do with the record. You asking for an unredacted document so you can confirm what has been represented to you by the government is, in fact, true and correct. Verify. So the biggest problem we've seen in the opposition to our motion is that this August 2 memo, I'm not sure what we would refer to it as, is the only document that's been provided by the government to verify that. In fact, they did not violate the special counsel statute or regulation. It seems very irregular for, and then he's cut off by the court, and the court responds, there isn't any guidance in the statute. What is it? Mr. Downing, no, the statute says specifically directed. Special counsel. As you know, this is the special counsel responding. As you know, the regs came about in a response to Congress, and a bipartisan commission decided that having a continuation of the independent counsel statute was a bad idea. They were really bad results. So the regs, as adopted, basically said to Congress, to the courts, and to the American public, this won't happen again. We have a politically accountable officer of the government, the Attorney General, and we have specific factual mandate if a special counsel. Then he's cut off and the court responds, by politically accountable, what do you mean, Mr. Downing? I mean someone who is Senate confirmed and appointed by the President of the United States. The court responds, serves at the pleasure of the President? Mr. Downing, correct, Your Honor. The court responds, so could be fired? Mr. Downing responds, correct. The court responds, go on. Mr. Downing is now responding, that politically accountable officer is now the acting Attorney General because of a conflict or a recusal that occurred with the Attorney General. That conflict was necessary for the acting Attorney General to look at the special counsel statute and say, okay, I need to appoint a special counsel. Now what happens next? Under the regs, it says a specific factual description, which you have in .1, I would agree. Then for any additional jurisdiction, for any additional matters to be investigated, the acting Attorney General, the politically accountable government official, has to grant additional jurisdiction. It doesn't say, sure, go ahead and do something else. It says jurisdiction because unless the acting Attorney General conveys jurisdiction on the special counsel, the special counsel has no authority to act. The special counsel is very limited. He has the authority of a U.S. attorney to the extent he's been given specific jurisdiction and additional jurisdiction. That second part of the appointment order completely eviscerates the special counsel regulations that require that the special counsel come back to the acting Attorney General, confer if he wants to expand his investigation, And then there has to be a determination by the acting attorney general to grant additional jurisdiction. On the record we have in front of us right here, that did not happen. What we've asked for is for the government to produce the record. The investigation that ends up here was an investigation that was being conducted by the U.S. Attorney's Office in the Eastern District of Virginia for quite some time. We have no record of how that investigation got transferred to special counsel. We have no record how an investigation involving banking issues made its way to the special counsel. We only have, and he's cut off by the court, and the court responds, well, let me ask you, so what? In other words, is what you're arguing that the use of that investigation in this case is contrary to the regulation that requires the acting attorney general here, Rosenstein, to be specific about what areas he wants investigated. And you're saying he was too general? In this supplemental, does he remedy that in the August 2 letter? Mr. Downing responds, he can't retroactively remedy it. The question is, as of that date, what he did, does it give jurisdiction to the special counsel? Or is it still so unrelated to the specific mandate as to be in violation of the regulations and the underlying statute? That's the question. You, I think, early on got right to the point, which is this doesn't really make any sense. This doesn't look like it's related. Prior cases, and there are cases that involve the special counsel, always look to it is it demonstrably related. The idea here is to keep a narrow jurisdiction on the special counsel to not end up with another independent counsel. When you see B and double I, it looks like another independent counsel. It didn't even require for Mr. Mueller to go back to Mr. Rosenstein if he wanted to expand under B and double I. It just says anything that arises or may arise. That, then the court cuts him off. Court responds, let's assume for a moment your argument that this delegation is in some way illegal. Why isn't the right result simply to give the Eastern District of Virginia's U.S. Attorney's Office, give it back to them, let them prosecute this indictment? Why isn't that the right result? Mr. Downing responds, well, the right result may be for the Department of Justice to finish the investigation they had started and make a determination as to whether or not to charge Mr. mannaFord. But if, in fact, this order is defective, then Mr. Mueller did not have the authority of the U.S. Attorney to conduct a grand jury investigation, to get search warrants, or to return and sign an indictment. The court responds, all right, I think I understand. Is there anything else you want me to? And then Mr. Downing responds, we make, I think, one point for the court, and I think it's an important point. The government had argued initially that these matters arose during their investigation. I think the government is now admitting, no, they didn't. That's a big admission, and it wasn't in their papers, all the way up to being in court here today. I have not heard the government admit to the court that that's exactly what happened. It looked like. The court responds, that's exactly what happened, Mr. Downing, that they grabbed these investigations from other components of the Department of Justice in the U.S., and then the court cuts him off and responds, you should say these investigations. Are you saying this indictment against Mr. mannaFord? Mr. Downing responds, yes, Your Honor. The court responds, all right, go on. Mr. Downing responds, so in their papers, they've been arguing, oh, they came upon this during their investigation. That's not the facts. So I'd like to make that record clear that their arguments in their brief are absolutely erroneous. It didn't arise during it. And I think that matters because of their other argument was, well, this whole thing falls into the first specific description, which I think you've pointed out. In no way does it make any sense that it falls into the first description. Then finally, when you go look at Mr. Rosenstein's memo, it is very odd for it when it occurs. But the most obvious omission from it is it does not say as we agreed or as we discussed. It just puts something in a point in time with no relation back to what happened on or before May 17th. And just one other issue. The government continues to refer to these regulations as no different than something that would be in the U.S. Attorney's Manual or a written policy. Obviously, the Department of Justice for some time and the Attorney General decided to make these special counsel regulations. They didn't make it a policy. They didn't make it a procedure. They didn't put it in the U.S. Attorney's Manual. They made it a regulation. And they did it publicly to say to the country, to Congress, and to the courts and the land that this is how we're going to conduct ourselves. The Attorney General certainly at points in time could have taken that right back, but he never did. He left it on the books. They promulgate that these regs are controlling the office of this special counsel in a public notice, their appointment order. So they tell the world, don't worry about it. We're not going to end up with this runaway special counsel like we've seen with the independent counsel. When they come to court, they say, by the way, these are not judicially enforceable. It's as if they hoodwinked the entire United States into thinking that this was going to be different than the independent counsel. I think it's very important for the government to be held accountable just like the government was and the Department of Justice was in U.S. versus Nixon. You put these regulations out there, you're telling the world, you're telling the government, you're telling the United States citizens, you can rely upon us conducting ourselves in this manner. Then, when they don't, and they don't produce a record, they say to this court, they say to mannaFord, they say to the country, guess what? It's not enforceable. And I don't think that can stand, Your Honor. The court responds, all right, let me hear your response. You've already made most of it, but repeat what you feel is necessary. Mr. Dreeburn responds, thank you, Your Honor. Let me try to make 4 quick points and answer any questions that the court may have. First, Mr. mannaFord's counsel treats the May 17th order as if it is the specific factual statement that's contemplated by the special counsel regulations. It is not. The regulations nowhere say that a specific factual statement needs to be provided publicly and in the context of a confidential, sensitive counterintelligence investigation that involves classified information. It would not make any sense for that information to be conveyed publicly. Mr. mannaFord actually acknowledged that in argument in this issue before the district court in the District of Columbia. The specific factual statement, as Attorney General Rosenstein described in his congressional testimony, was conveyed to the special counsel upon his appointment in ongoing discussions that defined the parameters of the investigation that he wanted the special counsel to conduct. So it is not really appropriate to assume that the B and the I description is the factual statement that the regulations contemplate. The court responds, well, I understand your argument, but let me characterize it and see if you find it as satisfying as you appear to indicate that you think it is. We said this is what the investigation was about. Well, we're not going to be bound by it, and we weren't really telling the truth in that May 17th letter. I don't watch pro football, but I used to enjoy the program that came beforehand, where a bunch of players would get on and essentially make fun of everybody. But they would put on some ridiculous thing, and then they would all say in a chorus, "Come on, man." I love that. I thought that was great. So your argument that we said this was the scope of the investigation, but we really didn't mean it because we weren't required by any law or regulation to say what the scope was. I understand that argument, but it kind of invites, come on, man. You said that was it. But I think your argument goes on and you say, look, the May 17 letter isn't the end of it. There is the August 2 letter. And in the August 2 letter, it's expanded considerably because it then says Russian government is number one. And then it goes on to the Ukrainian government, which is never mentioned beforehand. Who knows what else, of course, went on? In any event, I wanted you to be clear how I understand that particular argument. Mr. Dreeben responds, I can take a shot at explaining why I don't think that's the accurate way to look at it. The court responds, of course you may. Mr. Dreeben, so we're dealing here with a national security counterintelligence investigation that has been conducted by the FBI that had numerous different aspects to it that were, and then he's cut off by the court. The court responds, you are telling me that in this indictment that's before the court on Mr. mannaFord, that I'm going to have to go through CIPA, that there's going to be a Section 4 filing, that there will be classified documents, they'll have an opportunity to say what they need to say, et cetera, et cetera. Mr. Dreeben responds, I hope not, Your Honor. I was trying to describe the overall. It's cut off. The court responds, well, you're making a big deal out of it being a classified kind of thing. If that's in any way relevant to this defense, there we go with another CIPA. I have been through CIPA cases going way back to John Walker Lind and other matters. If that's what's going to happen, I'd like to have notice of it. You all could drag this out. I'm an old man. You could actually outlive me. This guy's a character. Mr. Dreeben responds, I'm not trying to do that, Your Honor. The court responds, this proceeding could outlive me. In fact, if a lot of lawyers around here had their way about it, they would take steps to ensure that almost everything outlived me. Mr. Dreeben, let me try to be brief. The court responds, all right, sir, that's welcome. Mr. Dreeben, the May 17th, he responds, he says, the May 17th order could not fully describe the matters that the acting attorney general wanted the special counsel to investigate because they implicated people who were under investigation, but who may never be charged, and sensitive national security matters. As a result, the specifics of the investigation were conveyed to us not on the face of the May 17th order, but in interaction with the acting attorney general. He explained this in his testimony in just these terms, simply could not be made public. I think Your Honor would agree that it's not appropriate for the government to disclose specific subjects of an investigation when those matters may never result in a charge and when they could jeopardize ongoing criminal investigations, as well as reveal national security matters. That was the only point that I was trying to make. One, and then small lowercase b, lowercase I in parentheses, is not the factual statement. The court responds, all right. Mr. Dreeben, the second point here is that we are within the Department of Justice to the extent that Mr. mannaFord is suggesting that we're analogous to the independent counsels that operated under the old statute. That's not right. Our indictment was reviewed and approved by the Tax Division, by the National Security Division. We operate within a framework of the Department of Justice. We're not different from the U.S. Attorney's Office in that respect. We're all part of the same Department of Justice. The court responds, you resisted my suggestion to have someone here, and Mr. Insonye showed up. When did you ask Mr. Insonye, Esonye, to join you? Okay. By the way, don't nod or shake your head out here because it interrupts the speaker. It's rude and it has often the opposite effect you may. I was never able to do that, by the way. When I was sitting where you are, I nodded and shook my head all the time, despite the fact that it aggravated the judges. I did it and I regret that. My perspective is a little different now. I expect you to do what I was unable to do. Don't worry about it. It's not a big deal. Go ahead. This guy kind of says says it when he wants, doesn't he? Mr. Dreeben responds, thank you, Your Honor. We took your admonition to heart, and we are very happy to have Mr. Insonye join us. The court responds, good. I think that's important for communications as well. Plus, you never know. If you have to try this case, you will have to try it before me. Mr. Insonye has some experience here. Is that right, Mr. Insonye? Mr. Insonye responds, yes, Your Honor. Court, and before me as well? Mr. Insonye responds, yes, Your Honor. The court, so he can tell you some interesting things. Mr. Dreeben, two more quick points with leave, Your Honor. Court says yes. Mr. Dreeben, first, Your Honor referred to the fact that there were ongoing investigatory matters that concerned Mr. mannaFord before the appointment of the special counsel. But the investigation that the special counsel has conducted has considerably advanced and deepened our understanding of the matters that have been previously identified. So it is not entirely fair to say that the matters in the indictment did not arise from the investigation or could not have arisen from it because our investigation, and he's cut off, the court responds, it factually did not arise from the investigation. Now, saying it could have arisen under it is another matter. But factually, it's very clear. This was an ongoing investigation. You all got it from the Justice Department. You're pursuing it. Now, I had speculated about why you're really interested in it in this case. You don't really care about Mr. mannaFord's bank fraud. Well, the government does. You really care about what information Mr. mannaFord can give you that would reflect on Mr. Trump or lead to his prosecution or impeachment or whatever. That's what you're really interested in. You know, when a prosecutor is appointed, he's appointed to get an indictment. He's appointed to go after somebody. Somebody mentioned to me not long ago that this is a different scheme, that it's not the scheme that was in effect in the 70s, in the 60s, and the 70s. That's true. But I suspect the change in this process is not significant. It's still the same. It's still the same. You appoint a prosecutor, and that prosecutor goes after with intent, whether it was Clinton or whoever else it was, Reagan or whoever, they go after. They go after him with the idea they've got to get an indictment. If they don't, they're very unhappy. I remember speaking to one special prosecutor, the Iran-Contra thing, and he was terribly disappointed. That's what prosecutors do. I understand that. The Brits use a different system. They don't use special prosecutors. They use a commission to go out and investigate it and write a report. And then people sort of accept that. In this country, I don't think a commission could do the job you were all doing. It doesn't have the power to subpoena. It doesn't have the power to impanel a grand jury, et cetera, et cetera. I understand that. But it sure is less disruptive. In any event, your point, if I can distill it to its essence, is that this indictment can be traced to the authority the special prosecutor has given in the May and August letters. That, as far as you're concerned, is the beginning and the end of the matter. Mr. Dreeben responds, Yes, Your Honor, it is the beginning and almost the end. And this is my last point, I promise. The court responds, all right. Mr. Dreeben is now responding. The special counsel regulations that my friend is relying on are internal DOJ regulations. He referred to them as if they are a statute. I want to be clear. They are not enacted by Congress. They are internal regulations of the Department of Justice. The court responds, most regulations aren't enacted by Congress. They're promulgated by agencies pursuant to rulemaking authority. Mr. Dreeben responds, correct. The court responds, Congress doesn't do it. And Mr. Dreeben responds, correct. But he referred to them as a statute. I just wanted to be clear where, and the court cuts him off. Court says, yes, I'm clear about that. I've learned a few things. Mr. Dreeben, the fourth, they conclude in a provision that's applicable here, 600.10, by describing that these rules and regulations are not intended to create any rights that can be enforced by individuals in any proceedings, civil or criminal. The court responds, yes, I have that in front of me. Mr. Dreeben responds, the reason for that is that this is a way for the Department of Justice to organize its investigatory prosecutorial actions. It's no different than the acting attorney general assigned a matter to the Eastern District of Virginia or assigned it to a component of the Department of Justice. It's not there for the benefit of the individual. The court responds, of course. The difference is that if you did assign it to an Eastern District of Virginia, it wouldn't come. Mr. Saunier, with a $10 million budget, would it? Mr. Dreeben, Your Honor. The court, look, I take your point on 600.10, that it doesn't create any rights. But that's a little bit like arguing, look, we issued these internal things, but don't expect us to be bound by them. I think your stronger argument is you complied with them. Mr. Dreeben, I agree, that is a strong argument. Court, it's not a very strong argument to say, don't hold us to it because we didn't mean it. We said it, but we didn't mean it. Mr. Dreeben, I can refer the court to a Fourth Circuit case that interpreted very similar language and concluded it was not enforceable in a court. Time for a drink.
Yeah, Thumper.
Hey, Mo. Okay, got the whistle wetted here, and so let's keep rolling. Getting close to the end. I'm about about 4/5 the way down the page. It looks like here. Maybe.
By the way, Thumper.
Yes, sir.
You're doing a fantastic job.
Oh, thank you. I'm going to be worn out. You'll not hear me on the microphone the rest of the day after I get finished with this. I've used up all my words.
Well,
there's people in chat going, "Yay!"
Yeah, Thumper, my hat's off to you as well. No other place would go into this in this kind of depth. Thank you so much.
Well, I hope you've gotten something out of it.
I tell you what, I seriously love this judge.
He's good, isn't he?
No kidding. He's taking them in bite-sized chunks and feeding it back to him.
Oh, he definitely is. Okay, I got my whistle wetted, so let's dive in here again. Okay, so we're going to start out here just what I got at the top of the page. It might be a repeat, but just bear with me here. Mr. Dreeben responds, I agree, that is a strong argument. The court then responds, it's not a very strong argument to say, don't hold us to it because we didn't mean it. We said it, but we didn't mean it. Mr. Dreeben responds, can I refer the court to a Fourth Circuit case that interpreted very similar language and concluded that it was not enforceable in a court. The court responds, yes, of course. Mr. Dreeben, we cited this case in our brief. It is in Reshane. It's 978F.2D 850. It's a 1992 decision of the Fourth Circuit, and it concerned the media subpoena regulation that the department has, which it has established in order to put a buffer zone around subpoenas that may go to the media. It's not required by the First Amendment, but reflects the Department of Justice's internal sensitivity to seeking information from the media. The litigant in this case claimed that the department had violated that regulation, issued a subpoena that wasn't authorized by it, and the Fourth Circuit concluded that this was an internal DOJ regulation. It contained language very similar to 600.10, and the Fourth Circuit held this is not a matter for courts to enforce. It's an internal DOJ matter. Respectfully, Your Honor, although we fully agree that we are authorized to conduct this investigation, there's no basis for dismissing the indictment. I would also refer you to this case. The court responds, wasn't there a matter in New York recently that the special counsel returned to the Southern District of New York? Mr. Dreeben, the special counsel's office did refer certainly allegations concerning an individual to the Southern District. The court responds, why did it do it? Mr. Dreeben, with respect, Your Honor, I'm not at liberty to go into the internal prosecutorial matters within the Department of Justice. The court, let me ask you this. Did it do it because it concluded that it had uncovered materials that really weren't within the scope of what it was authorized to look into? Or did it do it because, well, we're not interested in it because we can't use this to further our core effort, which is to get, and then he's cut off by Mr. Dreeben. He responds, let me try to answer Your Honor's question this way. The court responds, to Trump? Mr. Dreeben, because I want to be responsive and at the same time respect internal investigatory equities. The court responds, I'm not asking you to disclose anything that you can't disclose. Mr. Dreeben responds, we take very seriously the primary mission that was assigned to us by the acting Attorney General in the May 17 order, which is to investigate, not prosecute necessarily unless there's a prosecutable crime, but to investigate Russia's interference with the 2016 presidential election and leaks or coordination that may have occurred within individuals associated with the campaign of President Trump. We are focused on that mission. We may uncover other criminal activity in the course of that is necessary for us to investigate in order to complete that mission. We may uncover criminal activity that is not necessary for us to investigate, but is still appropriately investigated by a different component of the department. We have sought to respect that line. We have consulted with the acting Attorney General in order to make sure that we are operating within. The court cut him off. The court responds, all right, that's helpful, but it brings me back to a point that I don't know what we adequately plumbed. And that is, why in New York did you feel that it wasn't necessary for you to keep that, but that it is necessary for you to keep this, which involves bank fraud and registration and other things dating back to 2005, 2007, which I think manifestly don't have anything to do with the campaign or with Russian collusion. You're keeping one and giving up the other. I don't see the difference. I think one answer you could tell me, and I want to say it because I think you would properly be a little reluctant to do it. It is this. It's none of your business, Judge, why we did that. We're going to proceed on that. Well, I think that's a fair point to make. I'm not sure it's none of my business because I don't have yet a full understanding of everything. But why is New York different? And if you can tell me, I accept that. Mr. Dreeburn, well, Your Honor, I think I can be helpful to you about this case. In this case, Mr. Manafort clearly is within the area of investigation because of his affiliation with the campaign of President Trump and because of his affiliations in Ukraine with Russia associated individuals. Once a prosecutor, and the court interrupts, suppose you found a crime that he committed. Let's say the statute of limitations was 20 years ago. Would that permit you to go after him and use it to coerce him or put pressure on him to turn on others or Trump himself? Mr. Dreeburn, if it's not factually linked to the subject of the investigation, then we would go back under the regulations if we thought it was appropriate for us to investigate and have the acting attorney general decide that. But here, the crimes, and then he's cut off by the court. Court responds, can you tell me how these things in the indictment are factually linked to the Russian influence over the 2016 election? Mr. Dreeben responds, they're factually linked to the areas of our investigation because in trying to understand the activities of Mr. Manafort in Ukraine and associations that he may have had with Russian individuals and the depth of those, we need to understand and explore financial relationships and to follow the money where it led. So the logic of the investigation has factual connections to the indictment. I think in Your Honor's hypothetical that would not have been so, and that's the fundamental difference. The court responds, all right, I might mention to you that I've gone through the indictments as you would expect me to do. There's no mention in the indictment that I know of that refers to any Russian individual or any Russian bank or any Russian money or any payments by Russians to Mr. Manafort, correct? Mr. Dreeben responds, I think that is correct, but the money that forms the basis for the criminal charges here, the tax charges, the bank fraud charges, comes from his Ukraine activities. That's what we are focused on. So we followed the money into the transactions that led to the criminal charges here. And it's that factual link that connects the subject of the investigation and then he's cut off by the court. The court responds, you can't be talking about bank fraud because that's not where money comes from. Where money come from? That's getting money from a bank without telling the truth. But it could be in the false income tax. Is that what you're suggesting? Mr. Dreeben responds, it's both, Your Honor, because the Ukraine money was used to purchase and improve real estate. The transactions that are charged as bank fraud extracted that money and made it, and then he's cut off by the court. The court responds, purchases of his homes. Mr. Dreeben responds, with money that he derived from the Ukraine activities we've alleged. That's the factual connection, Your Honor. I'm just trying to explain why we regard this as connected to our investigation. The court. All right. Thank you, Mr. Dreeben. Thank you. The court. Do you have anything else to add? Mr. Downing responds, just briefly, Your Honor. The one thing we would ask this court to do before deciding the motion before the court is to ask the government for what anybody who had any experience with the Department of Justice, something weird just happened, who has any experience with the Department of Justice knows exists, which is the written record. Here is the written record before Mr. Mueller was appointed. Here is the written record about the decision. Court cuts him off. Court says, what do you mean by the written record? Mr. Downing, Mr. Rosenstein had a process we had to go through in order to determine that there was a conflict that gave rise to the appointment of special counsel. The specific matter that the special counsel was going to investigate in any additional jurisdiction he granted. It would all be written down somewhere. That's how the Department of Justice works. Mr. Rosenstein even conceded when he was testifying up on the Hill that he was confronted with the question of, when did you expand the jurisdiction to the special counsel? He couldn't or wouldn't answer the question. But he did say very tellingly, I will go back and check my records, and I will get back to you. So we could ask that this court order the government to turn over those records so that the court doesn't have to guess what happened. The court responds, what records is what I'm asking you? Mr. Downing responds, well, Mr. Rosenstein referred to records. The court responds, in his testimony. Mr. Downing responds, correct. The court responds, what records are you referring to, that is? What kinds of records? Mr. Downing, well, Your Honor, generally, and then the court cuts him off. Are you suggesting that Rosenstein had to go through some process to conclude that there was some conflict before the Department of Justice could proceed? Mr. Downing responds, which he also testified to. The court, all right, is that what your, and then he stops, and then the record of identifying the conflict? Mr. Downing responds, I believe identification of the conflict, the matter that needed to be referred to a special counsel in order to, because of the conflict. I don't know if those are redactions or what, but there's kind of a space there. And the scope of the special counsel's investigation, including any additional jurisdiction. The court responds, the May and August letters are the scope. Mr. Downing, that's after the fact. You would expect the Department of Justice, especially Mr. Rosenstein, would have had a memo before. The court, why do you say that? Mr. Downing responds, because in the Department of Justice, generally, just in any situation, he's cut off, the court responds, did you serve in the department? Mr. Downing, 15 years, 5 of which was under Mr. Rosenstein's management. Mr. Rosenstein is a stickler for memos being written, for there to be a written record for the actions of the Department of Justice. The court responds, what good would that do me if I had all of that in front of me? Mr. Downing responds, it might show you exactly whether or not Mr. Rosenstein violated the regs or whether he complied with them. The court responds, I don't know about regulations, but let's suppose he violated. Of course, counsel has already pointed out that that's, in his view, irrelevant. But let's suppose it shows that Rosenstein didn't do a good job. So what? Mr. Downing responds, so our position is that to the
That was weird.
yeah, my meeting just kind of reset.
Is everybody back? I see you, Thumper.
Yeah, I'm back.
Yeah, I'm back. That's a bit strange.
There's a lot of strange things going on today. I'm having a lot of problems with my 3 computers I have here too.
I'm hooked up to a high-speed internet, so it's I don't have to worry about the Wi-Fi I've been having trouble with. But that was just off and then back on again. Very weird.
Thumper, we're almost done. Can you continue with it?
Yeah, no, I can continue.
Awesome. Yeah, we're back on. Thank you.
Sorry about that, folks. Just a minute, I gotta let Yappy butt in.
Have some water. That was a long read, man. I cannot believe he got through that. Incredibly valuable information.